Hello, my name is Philip Voluck. I am an employment practices liability attorney and am part owner of a national litigation law firm, Kaufman, Dolowitz, Voluck, and Gonzo. As an employment practice liability attorney who's been practicing more than 32 years, I can say with utter certainty that this is an area that every business, small, medium-sized, large, needs to be concerned about. We're talking about claims arising out of the workplace from disgruntled employees, ranging from sexual harassment to employment discrimination to retaliation to wrongful discharge. The list literally goes on and on. As an example, the United States Equal Employment Opportunity Commission in 2011 had more than 100,000 charges filed. That's more than at any time in the EEOC's history and at any time since the Civil Rights Act was passed in 1964. And that's one agency. Doesn't account for all the claims that are filed directly in court or those claims that are settled out of court. There are a number of preventive strategies that employers can utilize to avoid claims, and if claims do arise, can manage them effectively and economically. Among those preventive tools is employment practices liability insurance, commonly known as EPLI. It's no longer, in our world, the employment world, the new kid on the block, so to speak. It's a necessary component of any business's operational foundation. Like any other catastrophic loss policies, it provides employers with that peace of mind that they need in today's workplace. You don't have to be an attorney and you don't have to be in business to read and learn and hear about the massive verdicts being rendered against some of the largest companies in our country. Verdicts in the tens of millions of dollars. Those are verdicts arising out of employment cases, wage and hour violations, employment discrimination cases. The courts continue to expand the laws, both on a federal basis and on a state basis. The concept is one of inclusion. The EEOC, the Department of Labor, OSHA, and its other sister regulatory agencies are simply not content to be dormant and process charges. Quite to the contrary, they have budgeted initiatives designed to ensure compliance with their laws, but in reality to ferret out, if you will, potential claimants, complainants, what the EEOC refers to as vulnerable workers, and educate them about their rights. There are active outreach programs. Employees no longer need to ask, what do I do? It's a question of how many things do I do? How do companies avoid these claims? The fact that you're watching this video, that's the first step in deploying your best practices in the workplace. That is what is going to help you avoid claims. Deploying your best practices. There are a number of tools to aid you in determining what works, what doesn't work, what makes you a more insurable risk, what makes you more prone to the type of claims being filed today. One of the tools we happen to have is called the Intelligent Quotient Risk Management Factor, which is a self-audit that companies take to determine just how their workplace shapes up, both from a legal standpoint, a cultural standpoint, as well as a business standpoint. I urge you to talk with your broker or your agent. Ask him or her whether or not this type of coverage works for you. It often covers many, many losses, can be inexpensive depending on the number of employees you have, and is one tool you want in your war chest when and if a claim arises. A lot of these policies also have value-added services such as consultations for free during the life of the policy with attorneys just like me. In the alternative, as an employment attorney with 85 attorneys at my disposal, 7 offices across the country, we are positioned to serve any company's employment law needs.